Kwekwe, bonjour, good morning. J'espère que vous avez eu une belle soirée, que vous êtes en forme. Bonjour.
Good morning to all participants here and online. Thank you for being with us for this last day. And thanks also. Thank you also. I'm Wina Siwi from the Wendat Nation and from the Anishinaabe Nation, which are situated in Quebec. I will be your co-president with Adam this week. And I will try to integrate as much French as possible in this session, which is supposed to be bilingual, to integrate both colonial languages that enable us to communicate together as much as possible. So first, I would like to recognize and thank the people who organized the pipe ceremony at 7 o'clock this morning. As you know, let me remind you that the registration opened at 7:30 and regional caucuses started at 8 o'clock. We'll start in a couple of minutes, but I wanted to recognize the importance and the presence of the knowledge keepers, the elders, the women, children, youth, and persons from the LGBTQ and associated communities who are present here today. The pipe ceremony was handled by Leonard Wendell Tuckle and Nicholas Wake. It is important also to note that the smudging ceremony is available outside the room. For security purposes, they were not enable us to handle the smudging ceremonies here. But in room 209, there is support in 209. And in the Knowledge Keepers room, and 214 is also open where there is support, because there's a lot of traumatic events we talk about. So we're going to, at 11:30, we're going to do culture protocols, and we're also going to have a panel on indemnization. And given that we weren't able to handle this panel in July, we're going to start with this panel. And after, we're going to continue with the resolutions 2 and 4, which will be presented. So for that, I turn the mic to my colleague Adam.
Important day, business to be done today as well. So have a good day, everyone, online, here in person. And thank you for being here. Adam, over to you.
Miigwech, thank you very much. Miigwech Wina. And good morning. Good morning to everyone. Mao chikamunigijga wenogam kagjibayak. Goyak mawin kagian wish nawa wegagi tipka. Miwe gwachim nawa bojo anin danse. We are looking for a very good day. Good discussions to conclude our 3-day assembly. So just a couple of points again. I'd like to acknowledge the Knowledge Keepers Council and the elders that are here. Also the veterans, the women, the elders, the youth, the men, council members, all of our guests from the various nations across the country. Particular emphasis on, it was really good to see children here in the assembly when I would go to take a little break during the day. Yesterday, down the hall. It's good to see children here in the assembly room, children and youth, and that is predominantly the topic for this 3-day assembly, and it was heartening to see young people and children being involved and hearing some of the discussions and just being here. I think that was very important. Also, again, I want to acknowledge the pipe ceremony that was held, of course, every morning this week. It was held again this morning, and also the sacred fire that was lit at the Siksika Nation, the fire that is ongoing throughout the 3-day assembly. So miigwech for that. A reminder, we are dealing with very sensitive issues, and a lot of the topics and the presentations in the panel discussions, also from chiefs that get up to speak, are dealing sometimes with very sensitive issues, very traumatic issues, and can be triggering. And we want to let you know that there are supports here in the assembly room. There is smudging available. We did end up having some smudging here in the room on day 1. We were advised again by security that we are not to have smudging in the room here. We don't have the proper setup with permissions, protocols, I guess air circulation, but we do have that set up in room 209. So if you do need the smudge, we do have that available, room 209. Also, room 214 is available if you wish to speak and have discussions and be with the Knowledge Keepers Council. They are in room 214. So with that, I'm going to turn it back to Weena to again have some very important, it's important to acknowledge everyone. So Weena.
Miigwech, Adam. So I think what Adam wanted to say, or the person he wanted to acknowledge, maybe was the ASL team, so Accessibility Champion team. And yesterday I referred to Marsha Ireland, our star. So we're very honored to have the team here with us this week and today, and as well as Debbie's team. Debbie's on stage at the moment, so thank you for being here with us and to help us learn some sign languages. So on that, we're very excited to have the possibility to have a short but important session of basic sign language together with Marsha. As I mentioned yesterday, Marsha Ireland is from the Oneida Nation of the Thames, and she's an advocate for sign languages and especially Oneida Sign Language. So on that, I would like to welcome Marsha and turn the floor over to her. Thank you very much.
Yanko, Weena, and Adam. And I also want to extend Yanko to Marie. I'll introduce myself, Tehum Dagagum Dayan Miyugets. My English name or colonial name is Marsha Ireland. I'm hoping all of you are excited to learn some signs this morning. So we'll do a refresher. Sagoli. 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 I can't see way over there in the corner. Hello. Yes, Sagoli. And ASL, hello. Hello. Fire. That's how we would sign fire in Oneida Sign Language. Forgive the interpreter, I don't know that word in Oneida yet. And I'll show you the sign for ceremony. Which includes the 4 elements of ceremony: fire, creator, us as people, and our singing or communicating with creator. In ASL, they would sign ceremony like this. Again, ceremony. To smudge. So if you can imagine that your hand is the shell or the vessel that we've put the tobacco or sage in, and you smudge. If I was to smudge myself, or to smudge a room or each other. In ASL, you would have to finger spell it, so you S-M-U-D-G-E. In OSL, Nagitwa, Nagitwa. I'll do that again for all of you, which in Oneida, the translation would be to see you again, or see you there, Nagitwa. Yonko, 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 Yonko. We also see Miigwech. Miigwech, yeah. Yeah, Miigwech. Miigwech. And as I was corrected yesterday, in the western areas of these lands, we'll see this sign in giving thanks. Higher up in the air than what I was doing yesterday. In ASL, it's thank you. Does anybody know the sign for bye? And anybody brave enough, willing enough to stand up and share with us Nagitwa or goodbye? Don't be shy. No need to be shy. Anyone who's brave enough to share with us what they've learned this morning? That's okay. That's all right. Well, I will leave it with that and wish everyone good luck today. Our thoughts are with you. Yonko.
No. Remember the way to applaud in sign language. Miigwech, Marsha. So on that, I will first call this meeting to order at 9:17. So 9:17, the meeting is called to order. And on that, we will proceed with our first item on the agenda for this morning. We had to rearrange a little slightly the agenda for the morning. So the first agenda item is a panel, is a plenary panel, so an update on compensation and reform on First Nations Child and Family Services. This plenary was postponed from last July AGA, so the last 2024 Assembly AGA in Montreal. And it is very important that we give them the space to present the information they want to convey to the Assembly. So on that, I will invite to come and join us on the stage first Dean Janvier, partner at Deloitte, as well as Duke Pelletier. He's the acronym is SIC member, so SIC member, which means Settlement Implementation Committee. So they will talk about the compensation, and I welcome them on the stage. So who's first? Okay, so good morning. Good morning. I will now turn the floor over Duke Pelletier to start his presentation. Thank you very much. Morning. Do you have the presentation?
No, I don't. It's going to be, Dean's going to do it.
Okay, because...
You have yours all set up?
I already sent it in.
Okay, the clicker will be just here. Okay. Oh, over to you.
All right. Bonjour, Kanawea. Nigan Walsagan Abadgan Indigenous Kas, and Kondo Dem. I'm from Weequampong-Unceded Territory in Ontario, and I am a member of the Settlement Implementation Committee. And I've been appointed in that role through a national selection process that was conducted over a year ago, and we went through court approval to have both myself and Chief Derek Niepenak, as well as 3 of the class council lawyers to support the compensation process to allow for those that have been affected by the child welfare system from 1991 to receive a compensation payment. And part of their work with the Settlement Implementation Committee is all guided through the agreement itself. And one of the main roles is to support how that compensation gets out to each individual that's been affected by the child welfare system. And through the court process, a $40,000 payment has been identified. And through a lot of the work and selection process, Deloitte was selected to implement the agreement and allow for those payments to go out to each individual that is eligible. So we're going to hear about Deloitte's progress in being able to get these funds out to your communities and to the individuals that have been affected by the child welfare system over the years. So I'd like to pass the microphone over to Dean Janvier, who's leading that process on behalf of Deloitte. So, miigwech.
Good morning. Could I have my presentation put on the screen, please? I have it in English and French, both. Good morning, elders, leaders, ladies and gentlemen. It's an honor to be here today. Hi, Chief, my chief, sir. Thanks for being here to listen this morning, all of you. I know you had a long day yesterday. Appreciate the time to be on the agenda. Before I start, I should introduce myself, Dean Janvier from Cold Lake First Nation, Northeastern Alberta, Treaty Number 6. I'm Dennis Uthlinen, and I'm really happy to be a part of this process of providing compensation. Deloitte is the administrator for the process of compensation, and I'm a partner at Deloitte, and I'll be making the presentation here today. I don't see the presentation up on the screen yet.
No, Dean, they don't have it apparently.
It was provided to the AFN a couple of days ago, and they said they would have it available, but in any event, I'll just proceed with my presentation, and they can try to find it. Just so you know, I did make a presentation about this at the Assembly in Montreal in July to the technicians on day one. And the second presentation to you, Chiefs in Assembly, was delayed till today. So I'm going to proceed with the update. First thing is what it's not. What I'm presenting on today has absolutely nothing to do, zero to do, with what you were talking about yesterday. This is completely different, and it has only to do with the compensation piece, the $23.34 billion settlement, which was approved by the court back in June. So this is proceeding according to that final settlement agreement, which you, Chiefs in Assembly, approved some time ago and was ratified by the federal court. So I'm giving an update on that. For those of you who are unfamiliar, the final settlement agreement on compensation covers off First Nations Child and Family Services, Jordan's Principle, and the Trout class actions. And that's very unusual. Normally, class action only has one major settlement within it, one issue, one settlement. And this one has three or more, and different classes. And it's also unusual in the fact that it's supposed to last for like 20 years. Usually it's 4 to 5 years, maximum length. It's different in some other ways too. I'll get into that in a bit. But that's the main point, is it combines all of these different agreements. And right now, it's going to be rolled out in phases. And the first phase is going to be First Nations Child and Family Services and the related family class. That's what we're referring to today. So the overview of the classes: in the removed child class, there's estimated 115,000 potential claimants. That's just an estimate. It could be more, it could be less. We're not exactly sure. It kind of, we'll see when we get the claims coming in. But experts have estimated it to be that size. And those are for children who, while under the age of majority, between April 1st of 1991 and March 31st of 2022, were removed from their home or placed off reserve by child welfare authorities and placed into care that was funded by Indigenous Services Canada, or INAC back in the day. The Jordan's Principle class estimated somewhere between 58,000 and 70,000 people, and the Trout class estimated to be 104,000 people. And the Essential Service class, there's no estimate for that. Those would be First Nations children living both on the reserve and off the reserve, who were confirmed they had a need for an essential service, but faced a delay, denial, or gap in receiving that essential service, also between April 1st, 1991, and ending in November 2nd, 2017. The next class is the KITH, K-I-T-H, KITH child class, no estimate on that class size, who are First Nations individuals who, while under the age of majority between April 1st of 91 and March 31st, 2022, were placed off reserve with a non-family caregiver and where a child welfare authority was involved in the placement. And the last one is the caregiving parents or caregiving grandparents of all of the previous classes. So there are going to be hundreds of thousands of people affected by this settlement over time. So who is Deloitte and what do we do? We're a professional services firm, and we were chosen to be the administrator for this claim through a proposal competitive process. And our role is to administer the claims process that safeguards the best interests of the class members to make things easier for them to receive their compensation. Secondly, and this is new, we get to work with First Nations communities and to provide claims-related assistance to the claimants. That's new in this agreement, has never been in there before. We monitor and report on outcomes, and any issues we find, we can report to the Settlement Implementation Committee and to the court. This is also a new feature. As you know, in previous settlements, there have been problems that arise during administration of it, and there was no way to have any of them addressed. And we are also to make sure that your points of view as First Nations are reflected in the work we do, and we also provide notice to all of the class members who've been approved as eligible for compensation. So all the advertising you see about file your claim, that would be Deloitte that's putting those ads out there. So we are not a party to the agreement. We didn't negotiate anything. We were chosen after the agreement was finalized, and our job is to implement the agreement. We're just an administrator. So just want to make that clear. So the claim support model that I'm reporting on today. Okay, great, they found them, great. I just went through the classes and our role as administrator. Here we are. So the settlement agreement requires the administrator offer support that helps the claimant submit a claim, that we're doing it in a culturally sensitive and trauma-informed way. And the claimant, it's a claimant-centered process, so it revolves around the claimant. And also we have service coordination for additional supports. So these are the main ways that we're going to offer supports as well. We have a set of guiding principles. We want to preserve claimants' dignity and respect their experiences, recognize the healing journey, represent all of the diversity that's here today represented by the nations, and focus on individual empowerment. So as you go through the process yourself as an individual, you should be able to find out what's going on with your claim and understand the process at each step. Oops, excuse me. I can close my laptop now. So the way we're going to be doing this is we have a team within Deloitte, which is the administrator team. I'm the leader of that team. And then we have a workforce of people working on this as well. So for each region here, there will be a First Nations community liaison. You should already know about those people. With the exception of BC and Alberta, we're still working with those regions to determine who those people will be. And those people are responsible to keep you as First Nations informed about this process at every step of the way. Secondly, we have a workforce that will be put in place when the claims process opens. These people are called claims helpers. Claims helpers will be available to work with individuals each and every day to answer their questions, to support them through the process. And service coordinators, we are aware that there may be some people who require additional assistance with other issues in order to be able to fully complete the compensation process. So they'll be there to provide referrals and supports to help them access those services. And there's a contact center that's available every day for anyone who has questions about this, with a toll-free number listed there. And in the yellow box, there is supposed to be, provided by the Government of Canada, additional resources to you, First Nations, to support your people through mental health and other services. But that has nothing to do with us at Deloitte. We're the administrator. But I just wanted to point that out here, that there is supposed to be additional mental health and other support resources provided to you as First Nations to support First Nations citizens. So I kind of covered this, the role of the community liaison, role of the claims helpers. Yeah, the claims helpers, we are going to hire 160 claims helpers across Canada. So some of them will be able to support in person, and others will be supporting virtually. and this will not there will be no cost to the individual to access these services. As well, they will be providing information about the settlement and the claims process, and they will be able to help claimants fill out and submit their claims, help them to obtain supporting documents if needed, and also to assist them through an appeals process if necessary. So 100 will be supporting in each across the country to support First Nations in their communities, 30 in specific urban areas where there are high concentrations of our people living, and 30 that will be available virtually and or to work with specific populations such as people who are incarcerated, for example. So total of 160. And depending on the amount of demand we get for these kinds of supports, we have authority to, once we have data to support it, to hire an additional 40 if needed. So a maximum of 200 at this time. And each year we'll be looking at the data of what the demand was, and we'll be resubmitting a budget, and if needed we can move this number upward if there's more demand for these services than currently we estimate may be required. Service coordinators. What we're going to be doing is the claims helpers can refer claimants to support additional support if needed to get help to meet their needs. And it's not clinical care, so they'll be supporting them in a way of guiding them, facilitating them through the process of accessing existing services that are already there. And each region will have a service coordinator, regional manager, so that's similar to the regional liaison. So they'll be working with all the different organizations in that region to make sure that they have fully up-to-date lists of services that are available, and they'll provide that to the service coordinators. So the service coordinators will work directly with the claimants to understand what services they require, identify the services that are available, and to give them referrals to those services. So the claim support process, this is a diagram of that. The process itself is going to be unlike previous processes. So in order to access their compensation, individuals do not have to put forward their life story. They don't have to produce a narrative of that. They just need to fill out a very short and brief claims form, which will have their name, their date of birth, their First Nations registry number if they have one, and provide some identification, government-issued identification. It's a very short form this time. And the reason for that is we have access to the payment database, which should contain their name, their date of birth, and that kind of information. And it's as simple as if once that's verified, and then that's the individual, that would be the basis for which they receive their compensation. So it's a much more trauma-informed approach than previous claim processes. So if someone has questions about this, they can go to the contact center. They'll have a frequently asked question capability, and if they don't get the answers they need there, they would be referred to a claims helper. If a claims helper can help them through the whole process, unless they have extra special needs, in which case they would be referred to a service coordinator and then referred to various community supports indicated in the yellow box, such as cultural supports, mental health, addictions, health, social, youth peer supports, or financial information, for example. So some people may not require any support. They might just be able to go to the website and apply and go straight through and receive their compensation without any kind of support. So the other nice thing about this process is it's not a one and done approach. If for some reason someone can't complete the process at a certain time, they can always go back and start over to complete the process. So it's helpful in that regard as well. So the claims process is not yet open. We're still waiting for authorization from the parties to open the claims process. And once it's open, the goal is to get the compensation to the claimants as quickly and effectively as possible. The timeline is expected, according to the settlement agreement, before the end of this calendar year. And the settlement agreement will be rolled out in phases, as I mentioned earlier. So right now we're in phase 1A, and we're waiting to start phase 1B, which is to open a compensation process for the First Nations child and removed child family class. And then after that, we're waiting for the results of a pilot project on Jordan's Principle process. And once the parties inform us regarding that process, we can start to design the claims process for Jordan's Principle, Trout, and Essential Services classes as the next phase of the rollout, but that's not happening yet. And then the last phase will be for the Kith child and Kith family class. So the claimant journey, step one is the claimant will submit the claims form. 2, it'll be adjudicated. 3, the adjudicator, they'll verify the claim with the ISC database. And then the 4th one is adjudicator can evaluate the family class. And the last one is the claimant receives the eligibility decision letter. But the family class one will be slower because we're expecting multiple claimant filings for various individuals who were removed. So all of that information has to come in and be reviewed before payment can be issued. Update on recruitment. So liaisons, as I mentioned, we have 10 of 13 planned already hired. As I mentioned, we're still in discussions with the Alberta region, who doesn't have a regional organization or a regional chief. So we're dealing with each organization individually. And as well, in British Columbia, we have a meeting scheduled in the near future to discuss their needs. And claims helpers, currently, as of now, we have 95 of the 160 currently hired, and we're still accepting applications, and they can be applied for through the website castlemaine.com, or they can email the resume to jobs at FN Child Claims, that's like First Nations, fnchildclaims.ca. That should say CA, not .com. That's an error. So what can you do now if you're potentially part of this claimant group of removed child class? You can ensure that you have your ID up to date, and we recommend that you have a bank account. Bank accounts are the most secure way to receive payment and the quickest way. So once your electronic transfer goes into your account, you would have full access to the full amount immediately. There would be no hold. And the other problem is there have been instances in the past where someone was mailed by mail a check and someone else had taken that check from them. So that's why we do recommend these 2 things be done. Just covered that. Oh, wait, I'll go back. This is for representative claimants. So there will be some people who, for disability reason, power of attorney, public guardianship, or the deceased class, those people will have a representative, and it's the same. So one is to get the valid ID, and then the documentation that supports your legal appointment to represent a claimant who can't represent themselves. So final reminders, compensation process is not open yet, but it hopefully will be open soon. You can sign up to receive updates and news from the website fnchildclaims.ca. And I want to emphasize this. We have heard reports that some people are calling individuals and saying that they're approved and that they should give them all their personal information. And that's false. If any of your nation members, your citizens get these kinds of calls, please warn them in advance, but if they do, please ask them not to answer those personal questions. Okay, so just there's a fraud warning there. Another point is you don't need a lawyer to go through this process, but if you want legal advice regarding any of these aspects, there is class counsel lawyers that are available to answer that, not through Deloitte, but through these law firms that represent the plaintiffs. And those contacts and those services are also without charge to the claimant. And we'd be very happy to hear from any of you if you do encounter any fraudulent activity. If you could notify us, that way we can send out an additional update of warnings for fraudsters. You can reach us through the 1-833-852-0755 number or through the FNChildClaims.ca /fraud warning. So thank you. That's my entire presentation for today, and I'll have more of an update to provide to you at the next AFN Assembly in December. So if we have any questions, we have maybe a bit of time. Thank you. Masi.
Miigwech for that. So we have a few minutes if there is questions. So we'll take a question at the microphone number 1, please.
Judy Wilson, proxy holder for Skyloch First Nation. I just wanted to thank you for all that work and helping with explaining how that's going to roll out. So my understanding there'll be offices across the country. And one thing I'm concerned about, though, is some of the cases that aren't so clear. That, you know, there was things that happened and the children were taken away. I would actually say on grounds that, you know, weren't very substantial, but they were removed. And so how does the family go through disentangling all that? I can think of a few cases in and around our area where they're asking for help and they never actually really received it because it involved so many different parties. But the result was the children were taken. There was some blame to the parents, but they were like unjustifiable. They weren't really registered in such a way. So how do we help those families? Or is there like somewhere we can say, can you call this number and we'll help you disentangle this issue to see if you're eligible or the kids are eligible or however that's going to work? Because I'm thinking there might be a lot of cases like that. How do we sort out the eligibility and how do we sort out where the families can go from there? Because it was injustice to them, but they never ever got the help, and some of them are quite old cases. I'm hoping they are around 2006, because I know some of the kids, they're growing up now, but it did impact their families. So I was just thinking that. Thank you.
Miigwech. So on that, before turning the floor over for an answer, I just want to confirm that we will then go to microphone number 2 and then to the Zoom platform, and we will, after that, we'll close the discussion, the Q&A session for this panel. Thank you very much. So on that, I'll turn the floor over to you.
Thank you for the question. The best way I could answer that is if you have questions regarding eligibility, that would be, or specific certain cases that are complex, that is definitely a question that you would ask the class counsel, as I mentioned. It's not Deloitte, it would be the lawyers to get guidance on that. And the other thing I would say is if you are asked by an individual who was apprehended, should I apply, and they're not quite sure of the circumstances, like for example, they were too young to remember anything, or there's no living relatives left to give them any information, for example, I would say ask them to apply. And then once they go through the process, if they are eligible, that would be confirmed, right? That would be my answer to your question. Thank you.
Miigwech for that. Microphone number 2, please.
Hi, Michelle Sekobi, proxy for Chief Gabriel Atwin. The question I have is, as part of the implementation process, has the team begun a secondary process for the individuals whose names do not appear on the ISK database to ensure that they're receiving compensation as well? Like in Kingsclear Child and Family, they didn't send the names of the individuals who were in care to ISK. They used a numbering system. So that's my question.
Miigwech for that. So we'll look here to
Thank you.
AFN for an answer.
Yeah, thank you for the question. So the answer is, if someone is applies and for some reason through the review process that they are not found on the ISK database, but they have evidence to support what they're saying is true, because there could be instances like you just described, there is going to be an appeal process with an independent adjudicator, not from Deloitte. So an independent adjudicator will then review all of those facts, and they would then, if it's all correct, they would be eligible for compensation. So.
Miigwech for that. So I guess it's a clarification. So we will go online right after. We'll go back to microphone number 1 for a brief clarification, I guess. So microphone number 1.
Judy Wilson, proxy holder. I just wanted clarification on the dispute. What if there's a dispute? I think he kind of answered it. And same as the other lady, sometimes Ministry of Child and Family Development does not have proper records either, or ISK or whoever, right? Thank you.
If I understand your question correctly, you're asking me about a disagreement among family members regarding eligibility?
Two levels.
Yeah, I'm not quite sure I understand your question, sorry.
It's 2 levels. It could be in the family, but also that the records are being disputed. They aren't at Ministry of Child and Family or ISK. So I think you partially answered it by saying, oh, well, they could go through the eligibility process or talk to the attorneys, the claimant attorneys. But I think it needs to be a little clearer. Thank you.
Okay, so let me answer the first question first regarding disagreements among family members. So in that situation, I would expect that they'll all file for compensation. And then after the claims period closes, if there's a dispute or disagreement there regarding the child who was removed among the removed family class, all of the information will be considered all together. And then a determination will be made at that time. So that's the answer to the first question. The answer to the second question is the same as what I said to the other lady. So if someone disagrees with the decision by Deloitte, whether on their eligibility, there's an independent appeals process available to them, which they can provide that information, and a qualified lawyer will review that and make the final determination on eligibility. And if it's eligible, Deloitte will pay.
Miigwech, so we will go as planned with Chief on mic 3 on the Zoom platform. So Chief Mike Christian, over to you. Chief Christian on the Zoom platform. Yes, you're invited to open your camera to address the assembly and ask your question.
It says I can't open my camera, which is fine because my connection is kind of crappy. But as introduction, White Kohada, Pesquast is Mike Christian, Kukpi First Plechin, Te Shawat Makuluk. I'm just kind of curious, like I'm also a director for the National 60s Coop Healing Foundation as well. So like I went through that whole process of the last specific claim in relation to what was going on and kind of experienced like the issues in regards to that. So because I'm part of that group, I'm just kind of wondering if there's some kind of a connection, because like right now we're working on taking that data, metadata and everything from Collectiva, who was the one that collected all that information from the survivors. And we're trying to take it from them to get it back, put back in our care, like the survivors' care, so to speak. And I was just wondering if that was something that you guys were going to be doing as well.
Thank you, Chief.
Thank you for the question, and the answer is no. We're not working on that. We're working on the First Nations Child and Family Services Jordan's Principle Class Action Settlement Agreement.
Miigwech. So this is all the time we have in front of us, but we'll go for a brief clarification at microphone number 2, and then we will close this panel to get into business with resolutions. Over to microphone number 2, please.
I'm looking for some clarification. Because Kingsclear Child and Family, every single client that was in care was given a number that wasn't given to ISK. Does that mean every single person is going to have to go through an appeal process?
Thank you.
I don't know if your facts are correct, because we do have a database and we do have data for the claimants who are in the Atlantic. So we do have names, dates of birth, First Nation registry numbers available. So that information was recorded during the payment process. So the answer to your question is no. They won't all have to go through appeals.
Okay.
They can all be verified and paid like every other claimant across Canada. Thank you for the question.
Thank you.
And thank you, chiefs and proxies and elders and respected friends and family. Thank you for being here, and thank you for hearing us this morning. Thank you. Look forward to seeing you again.
Miigwech. So that concludes the panel on the update on compensation and reform of the FNCFS program. And thank you very much to our panelists, Dean Janvier from Deloitte and Duke Peltier from the Settlement Implementation Committee members, SIC, the acronym. Thank you very much. On that, as announced, I will now turn the floor to my co-chair, Adam, to get into business. Miigwech.
Miigwech, Weena, and miigwech to the panelists on the very important presentation and the questions that you've asked. So just to give you a recap in terms of the agenda, on the agenda for this morning, we did have the wrap-up, and we would start the closing protocols at 10 a.m. It is now 9:55. We did have a number of resolutions. What we propose to do is to start the process with the first 2 resolutions, and we'll see how the time goes from there. Just to be aware, we do have a number of other resolutions. It does not look like we will get to all of them. So we do have 2 resolutions. Just want to point out the 2 that we will be dealing with first are draft resolutions number 2 and 4. A reminder, the 2 resolutions do reject the final agreement, but they have different paths forward with different terms. And what I'd like to do is just briefly highlight some of the elements of both resolutions. Of course, each resolution is very specific. There are more details in each of the resolutions, but I just want to highlight some of the differences so that we are aware as we make decisions moving forward on both of those resolutions. So draft resolution number 2, it's titled Addressing Long-Term Reform of the First Nations Child and Family Services Program and Jordan's Principle. So this resolution rejects the draft agreement, both the July 11th version and the proposed October 7 amendments. Of course, we're all aware that there were amendments. The resolution calls to adopt a new governance approach. It establishes a National Children's Chiefs Commission, so that would be a new entity. It establishes a new negotiating team with regional representation and a new legal team. It provides direction on who to include in the negotiations. It also calls on Canada to seek a new mandate to negotiate. It directs that chiefs have 90 days to review any proposed reform to Canada's First Nation Child and Family Services and any other agreements. There's also other procedural directions on how the work is to be done, and that is, of course, all contained in the resolution. While I'm doing that, we've invited our friend Bram from the resolutions team to come up and join us as we get underway into the resolutions. So, the second resolution, just to let you know, there was also another resolution, draft resolution number 3, that has been withdrawn. So the next resolution would be draft resolution number 4. And draft resolution number 4, we don't have it up on the screen yet. We won't put it up, but it's titled Meaningful Consultation on Long-Term Reform of First Nations Child and Family Services. This resolution, again, it rejects the draft agreement, both the July 11 version and also the, obviously, the October 7 amendments. It calls for the Children's Chiefs Commission, which would be established in draft resolution number 2, to renegotiate a new agreement with several amendments, and there are procedural elements described in that resolution. It also calls on Canada to obtain a new negotiation mandate. It also calls on the AFN and Canada to refrain from bringing any new motions or seeking direction to set aside CHRT orders without approval of the First Nations in Assembly. So just a couple of things to consider. 2 resolutions. Again, they do reject the draft agreement, but they have different paths forward. So the resolutions are overlapping in certain areas. They both call on Canada to obtain a new mandate for items in their resolutions, but again, they are proposing different aspects. They also provide overlapping direction to the AFN, and of course one resolution, that's the second one, draft resolution number 4, depends on the first resolution on the establishment of the Children's Chiefs Commission. So that's the creation of a separate entity. So we just wanted to make sure people are aware. They are different resolutions, but they have similarities, but different paths moving forward. So with that, we will start with the resolutions. It's now 10 a.m. again. We'll see how timing goes. We had on the agenda allocated up until 10 o'clock to deal with business and start the protocols to close the assembly right now. But we will start the process and see how timing goes. So if I can have draft resolution number 2 up on the screen, and there it is. And what we will do is I will read the entire resolution, so it's going to take me a while. I think it's about 5 pages. And then I will have my colleague Weena read the resolution in French, because again, this is a very important issue. First, I want to confirm that the mover and the seconder are in the room. Draft resolution number 2 is moved by Kilsalem, Council Chair. Oh, yes, he's here. Seconder, Chief Ira MacArthur is also present. Thank you. So the mover and the seconder are here. Resolution, I believe you have, I know that hard copies were handed out yesterday afternoon, and you all have hard copies. It's also up on the screen. It's also online if you want to look at an electronic version. So it reads, whereas, A, recognizing the United Nations Declaration on the Rights of Indigenous People, UN Declaration states under Article 18, Article 19, and Article 37. I will not read those articles. B, recognizing the sacredness of First Nations children, youth, and families, and Jordan's Principle, a child-first legal requirement ensuring substantively equal and culturally appropriate access to products, services, and supports for First Nations children, and that the government entity of first contact pays for the support without delay. C, the First Nations Child and Family Caring Society, and the Assembly of First Nations, AFN, filed the Canadian Human Rights Act complaint in 2007, alleging Canada's inequitable provision of First Nations Child and Family Services, FNCFS, and its choice not to implement Jordan's Principle were discriminatory, resulting in serious and irremediable harms. D, the parties, CHERT parties to the 2007 Canadian Human Rights Act complaint included 1, the AFN, 2, the Chiefs of Ontario, 3, the Anishinaabe Nation, 4, the Caring Society, 5, the Canadian Human Rights Commission, and 6, Amnesty International. E, the Canadian Human Rights Tribunal, CHRT, substantiated the discrimination claim in 2016 CHRT 2 and ordered Canada to cease its discriminatory conduct immediately. F, between 2016 and 2024, the CHRT parties were required to hold Canada accountable and return to the tribunal on multiple occasions, resulting in 24 non-compliance and procedural orders. G, on December 31st, 2021, an agreement in principle, AIP, was signed as a framework for the negotiations of a final settlement agreement, FSA, on First Nations Child and Family Services, Jordan's Principle, and the reform of Indigenous Services Canada. H, the final settlement agreement will have a direct impact on unprecedented magnitude on the lives of First Nations children, youth, their families, and their communities for generations to come. I, the CHRT parties, have agreed to split the FSA negotiations with a Child and Family Services agreement to come first and an agreement on Jordan's Principle to follow. J, Canada has entered into negotiations with some of the CHRT parties, AFN, Chiefs of Ontario, and Anishinaabe Nation, to complete an FSA on Child and Family Services, while other CHRT parties are not included, the Caring Society, the Canadian Human Rights Commission, and Amnesty International. K, in 2022, CHRT 8, the CHRT ordered the creation of the Expert Advisory Committee, EAC, composed of independent and multidisciplinary experts to develop and oversee the implementation of an evidence-informed work plan to prevent the recurrence of discrimination by ISC. L, the CHRT ordered the federal government to work with the parties to completely overhaul the on-reserve Child and Family Services program and fully implement Jordan's Principle. M, as a result, an agreement was made to re-establish the National Advisory Committee on First Nations Child and Family Services Program Reform, the NAC, to address issues pertaining to child and family services reform, including funding, legislation, immediate relief, Jordan's Principle, and other reforms. N, the NAC was mandated by the First Nations and Assembly to provide expert advice on long-term reform of First Nations child and family services. O, the NAC has not completed its review of proposed funding model for First Nations agencies. 2, begun to review the proposed funding model for First Nations without agencies, or 3, met since February 8th, 2024. P, the AFN has not set any further NAC meetings despite requests to do so. Q, the AFN and the Caring Society requested that the Institute of Fiscal Studies and Democracy, IFSD, conduct immediate-based research to inform the reform of the FNCFS program and Jordan's Principle. R, recalling and reaffirming Resolution 40/2022 to ensure quality of life to the First Nations Child and Family Services program and Jordan's Principle, directing 1, the parties to develop evidence and policy-based options for the long-term reform of Jordan's Principle that will include mechanisms to enable and support self-determination and to return to the First Nations and Assembly for review and approval. 2, Canada to extend the timeframes for signing the FSA on long-term reform. The First Nations and Assembly must approve the FSA on long-term reform. And 3, Canada to fund the Assembly of First Nations National Advisory Committee on First Nations Child and Family Services Program Reform and regional and other technical experts to inform the FSA. S, in light of these legal proceedings and their outcomes, it is critical to ensure that any long-term reforms of the FNCFS program and Jordan's Principle are driven by community-led processes that reflect the needs of First Nations children and families, and that any agreements related to the FNCFS program and Jordan's Principle, the LTR agreements, shall meet the needs of First Nations children, youth, and families. Therefore, be it resolved that the First Nations and Assembly This is a long resolution, so I need a little bit of water. Bear with me, miigwech. Therefore, be it resolved that the First Nations in Assembly Final Settlement Agreement number 1 reject the draft Final Settlement Agreement on long-term reform of the First Nations Child and Family Services Program dated July 11, 2024, and the proposed amendments on the draft agreement on long-term reform released on or about October 7, 2024, and call for a new negotiation process for the LTR agreements to be developed and approved by the First Nations in Assembly based on the spirit and intent of this resolution. Governance and transparency of the LTR agreements for the FNCFS program and Jordan's Principle. Number 2, direct the AFN Executive Committee to adopt the following approach to the LTR agreement negotiations. A, establish a National Children's Chiefs Commission with representation appointed by every region, including regions not represented by the AFN, that will work openly and transparently to provide strategic direction and oversight of the LTR agreements negotiations, reporting back to the First Nations in Assembly. B, the Children's Chiefs Commission will establish a negotiation team with regional representation and a new legal team that will be responsible for carrying out the negotiations for the LTR agreements under the direction of and reporting to the Children's Chiefs Commission. C, the negotiation team's terms of reference for the FNCFS program will be provided to the First Nations and Assembly for approval no later than December 2024. And D, the Children's Chiefs Commission shall report to the First Nations and Assembly in December 2024 as to its anticipated timeframes for the completion of the negotiations in relation to the FNCFS program and on the anticipated timeframes for the terms of reference for Jordan's Principle. 3, direct the AFN Executive Committee and the Children's Chiefs Commission to ensure that governance structures set out in an LTR agreement shall uphold the sacredness of children, youth, and families, be transparent, open, and accountable to First Nations, preserve First Nations decision-making, and include the guidance of youth in care and formerly in care, and the First Nations Child and Family Service experts. 4, direct the AFN Executive Committee and the Children's Chiefs Commission to develop an open and transparent amendment process for the First Nations in Assembly to suggest changes, allow for consideration of those changes, and make changes to the LTR agreements before being put to a vote, such process to be approved by the First Nations in Assembly. 5, direct the Children's Chiefs Commission to provide a detailed report to the First Nations and Assembly on all suggested amendments, the decisions made on each amendment, and the outcomes of negotiations before the First Nations and Assembly proceed with any decision-making on the LTR agreements. 6, direct the AFN to refrain in the future from committing to support or otherwise make efforts to procure support from First Nations leadership on an agreement, arrangement, protocol, or similar instrument that has not been approved by First Nations in Assembly. inclusion and representation. 7, direct the AFN Executive Committee and the Children's Chiefs Commission to take positive and effective measures throughout the respective LTR agreement negotiations, review and approval processes, including the negotiation tables, to seek out and incorporate the expertise of A, First Nations, B, First Nations Child and Family Service Providers, C, Jordan's Principal Experts, D, Elders and Youth, E, the National Advisory Committee, NAC, F, Jordan's Principal Operations Committee, JPOC, and G, Regional Experts. 8, direct the AFN Executive Committee and the Children's Chiefs Commission to review and approve the terms of reference for the NAC no later than December 2024. 9, call upon Canada and direct the AFN Executive Committee to unconditionally include the Caring Society in negotiations of the LTR agreements on the FNCFS program and Jordan's Principle, and to conduct those negotiations pursuant to a negotiation protocol developed in collaboration with the Caring Society, including the requirement that those negotiations be conducted in a manner that is open, transparent, and accountable to First Nations. 10, call upon Canada to obtain a new negotiation mandate to address the matters in this resolution. Communication and feedback. 11, call on Canada to fulfill its obligation to consult with First Nations on any long-term reform approaches of the FNCFS program and Jordan's Principle in a manner consistent with honor of the Crown. 12, direct the AFN Executive Committee to postpone any votes of the LTR agreements on any other agreements until all First Nations have had at least 90 days to review and complete agreement with appendices available in both official languages. 13, call on Canada to ensure that First Nations who are not AFN members are given a formal opportunity to express their views on the LTR agreements, and for Canada and the AFN Executive and the Children's Chiefs Committee to fully consider and incorporate those perspectives into the LTR agreements. Voting. Number 14, direct the AFN to ensure that First Nations chiefs and proxies can vote on the LTR agreements virtually, in person, or by any other means via specific accommodation to a chief or proxy to accommodate First Nations leadership who are unable to attend in person due to community circumstances or emergencies. 15, direct the AFN Executive to support the EAC to conduct its work freely as an independent expert body and invite the EAC members and NAC members to present to the First Nations in Assembly in December 2024 and prior to any vote on the LTR agreements. Support and resources. Call on Canada to provide funding for First Nations to secure independent legal and technical advice, ensuring that all communities can review the LTR agreements with a full understanding of its implications. And that is the resolution in English. I'll now call on my colleague Weena to read it in French.
Miigwech Adam. So I know that some chiefs from the Quebec region just asked if you will hear that draft resolution read in French. So here I am for our brothers, sisters, and colleagues, friends that need to hear that in French. Alors,
therefore, we will now read the revised draft resolution. I will now read the first area, the whereas. And dear Anglophones present, since this was read in English prior, interpretation will start back soon.
B. Reconnaissant le caractère sacré des enfants, des jeunes et des familles des Premières Nations et du principe de Jordan, Une exigence juridique de priorité à l'enfant garantissant un accès substantiellement égal et adapté à la culture, aux produits, services et soutiens pour les enfants des Premières Nations et que l'autorité gouvernementale de premier contact paye pour le soutien rapidement. C. La Société de soutien à l'enfance et à la famille des Premières Nations, Société de soutien, et l'Assemblée des Premières Nations, APN, ont déposé une plainte en vertu de la Loi canadienne sur les droits de la personne en 2007, alléguant que la prestation inéquitable par le Canada des services à l'enfance et à la famille des Premières Nations, SEFPN, et son choix de ne pas mettre en œuvre le principe de Jordan était discriminatoire et entraînait des préjudices graves et irrémédiables. Les parties au TCDP, donc au tribunal, les parties à la plainte déposée en 2007 en vertu de la Loi canadienne sur les droits de la personne étaient les suivantes. I. L'APN. 2. Les chefs de l'Ontario. 3. La Nation Anishinaabe-Aski. 4. La Société de soutien. 5. La Commission canadienne des droits de la personne. Et 6. Amnesty International. E. Le Tribunal canadien des droits de la personne, TCDP, a confirmé le bien-fondé de la plainte pour discrimination dans sa décision 2016 TCDP 2 et a ordonné au Canada de cesser immédiatement son comportement discriminatoire. F. Entre 2016 et 2024, les parties au TCDP ont dû demander des comptes au Canada et revenir devant le tribunal à de multiples reprises, ce qui a donné lieu à 24 ordonnances de non-conformité et de procédure. G. Le 31 décembre 2021, une entente de principe a été signée pour encadrer les négociations d'une entente définitive de règlement, ERD, sur les services à l'enfance et à la famille des Premières Nations, le principe de Jordan et la réforme des services aux Autochtones Canada. H. L'entente définitive aura une incidence directe d'une ampleur sans précédent sur la vie des jeunes et des enfants des Premières Nations, de leurs familles et de leur communauté pour les générations à venir. I. Les parties au TCPD ont convenu de scinder les négociations sur la réforme à long terme de manière à ce que l'entente sur les services à l'enfance et à la famille passe en premier et qu'une entente sur le principe de Jordan suive. J. Le Canada a entamé des négociations avec certaines des parties devant le TCDP, l'APN, chef de l'Ontario, Nation Anishinaabe-Aski, en vue de la réalisation d'une ERD sur les services à l'enfance et à la famille, tandis que d'autres parties devant le TCDP n'étaient pas incluses, Société de soutien, Commission canadienne des droits de la personne et Amnesty International. K. Dans sa décision 2022 TCDP 8, le TCDP a ordonné la création d'un comité consultatif d'experts, CCE, composé d'experts indépendants et multidisciplinaires chargés d'élaborer et de superviser la mise en œuvre d'un plan de travail fondé sur des données probantes afin d'empêcher toute nouvelle discrimination de la part de SAC. L. Le TCDP a ordonné au gouvernement fédéral de collaborer avec les parties pour remanier complètement le programme des services à l'enfance et à la famille dans les réserves et mettre pleinement en œuvre le principe de Jordan. M. En conséquence, un accord a été conclu pour rétablir le Comité consultatif national pour la réforme du programme des services à l'enfance et à la famille des Premières Nations, CCN, afin d'aborder les questions relatives à la réforme des services à l'enfance et à la famille, dont le financement, la législation, les redressements immédiats, le principe de Jordan et d'autres réformes. N. Les Premières Nations en Assemblée ont conféré au CCN le mandat de fournir des conseils d'experts sur la réforme à long terme des services à l'enfance et à la famille des Premières Nations. O. Le CNA n'a pas 1. Terminé son examen du modèle de financement proposé pour les agences des Premières Nations. 2. Commencer à examiner le modèle de financement proposé par les Premières Nations sans agence. 3. Tenue de réunion depuis le 8 février 2024. P. L'APN n'a pas fixé d'autres réunions du CCN malgré les demandes qui lui ont été adressées. Q. L'APN et la Société de soutien ont demandé à l'Institut des finances publiques et de la démocratie, IFP, FPD, d'entreprendre des recherches communautaires pour orienter la réforme du programme des SEFPN et du principe de Jordan. R. Rappelant et réaffirmant la résolution 40-2022, assurer la qualité de vie dans le cadre du programme des services à l'enfance et à la famille des Premières Nations et du principe de Jordan, ordonnant 1. Aux partis d'élaborer des solutions stratégiques fondées sur des données probantes pour la réforme à long terme du principe de Jordan, qui comprendront des mécanismes permettant
2. Canada to extend the timeframes for signing the FSA long-term reform. The First Nations in Assembly must approve the FSA on long-term reform. And Canada to fund the Assembly of First Nations National Advisory Committee on First Nations Child and Family Services Program Reform and regional and other technical experts to inform the FSA. S. In light of these legal proceedings and their outcomes, it is critical to ensure that any long-term reforms of the FNCFS program and Jordan's principle are driven by community-led processes that reflect the needs of First Nation children and families, and that any agreements related to the FNCFS program and Jordan's principle, the LTR agreements, shall meet the needs of First Nations children, youth, and families. Now, therefore, be it resolved that the First Nation in Assembly, first category, final settlement agreement. Number 1. Reject the draft final settlement agreement on long-term reform of the First Nation Children and Family Services Program dated July 11, 2024, and the proposed amendments on the draft agreement on the long-term reform release on or about October 7, 2024, and call for a new negotiation process for the LTR agreements to be developed and approved by the First Nations in Assembly based on the spirit of intent of this resolution. Second section, governance and transparency of the LTR agreements for the FNCFS program and Jordan's principle. Paragraph 2, direct the AFN Executive Committee to adopt the following approach to the LTR agreements negotiations. A. Establish a National Children's Chiefs Commission with representation appointed by every region, including regions not represented by the AFN, that will work openly and transparently to provide strategic direction and oversight of the LTR agreements negotiation, reporting back to the First Nations in Assembly. B. Children's Chief Commission will establish a negotiation team with regional representation and a new legal team that will be responsible for carrying out the negotiations of the LTR agreement under the direction of and reporting to the Children's Chief Commission. C. The negotiation team's terms of reference for the FNCFS program will be provided to the First Nations in Assembly for approval no later than December 2024, and D. The Children's Chiefs Commission shall report to the First Nations in Assembly in December 2024 to its anticipated timeframes for the completion of the negotiations in relation to the FNCFS program and on the anticipated timeframes for the terms and reference for Jordan's principle. 3. Direct the AFN Executive Committee and the Children's Chiefs Commission to ensure that government structures set out in the LTR agreement shall uphold the sacredness of children, youth, and families by be transparent, open, and accountable to First Nations, preserve First Nations decision-making, and include the guidance of youth in care and formerly in care, and First Nations child and family service experts. 4. Direct the AFN Executive Committee and the Children's Chiefs Commission to develop an open and transparent amendment process for the First Nations in Assembly to suggest changes, allow for consideration of those changes, and make changes to the LTR agreements before being put to a vote. Such process to be approved by the First Nations in Assembly. 5. Direct the Children's Chiefs Commission to provide a detailed report to the First Nations in Assembly on all suggested amendments, the decisions made on each amendment, and the outcomes of negotiation before the First Nations in Assembly proceed to any decision making on the LTR agreements. 6. Direct the AFN to refrain in the future from commitment to support or otherwise make efforts to procure support from the First Nations leadership on an agreement, arrangement, protocol, or other similar instrument that has not been approved by the First Nations in Assembly. Next section, inclusion and representation. 7. Direct the AFN Executive Committee and the Children's Chiefs Commission to take positive and effective measures throughout their respective LTR agreements negotiations, review, and approval processes, including at the negotiation table, to seek out and incorporate the expertise of A. First Nations. B. First Nations Child and Family Service providers. C. Jordan's Principals experts. D. Elders and youths. E. The National Advisory Committee, NAC. F. Jordan's Principal Operation Committee, JPOC. And G. Regional experts. 8. Direct the AFN Executive Committee and the Children's Chief Commissions to review and approve the terms and reference for the NEC no later than December 2024. 9. Call upon Canada and direct the AFN Executive Committee to unconditionally include the Carrying Society in negotiations of the LTR agreements on the FNCFS program and Jordan's Principle, and to conduct those negotiations pursuant to a negotiation protocol developed in collaboration with the Carrying Society, including the requirements that those negotiations be conducted in a manner that is transparent, open, transparent, and accountable to First Nations. Paragraph 10. Call upon Canada to obtain a new negotiation mandate to address the matters in this resolution. Next section, communication and feedback. 11. Call on Canada to fulfill its obligation to consult the First Nations on any long-term reform approaches of the FNCFS program and Jordan's Principle in a manner consistent with honor of the Crown. 12. Direct the AFN Executive Committee to postpone any votes on the LTR agreement or any other agreement until all First Nations have had at least 90 days to review the complete agreement with appendices available in both official languages. 13. Call on Canada to ensure that First Nations who are not AFN members are given a formal opportunity to express their views on the LTR agreements, and for Canada, the AFN Executive, and the Children's Chiefs Commission to fully consider and incorporate those perspectives into the LTR agreements. Next section, voting. 14. Direct the AFN to ensure that First Nations chief and proxies can vote on the LTR agreements virtually, in person, or by another mean via specific accommodation to a chief or a proxy. To accommodate First Nations leadership who are unable to attend in person due to community circumstances or emergencies. 15. Direct the AFN executive to support the EAC conduct its work freely as an independent expert body, and invite the EAC members and NEC members to present their First Nations in Assembly in December 2024 and prior to any vote on the LTR agreements. Next section, support and resources. Paragraph 16. call on Canada to provide funding to First Nations to secure independent legal and technical advice, ensuring that all communities can review the LTR agreements with full understanding of its implications. This ends the reading of the revised draft resolution in French. Number 2, draft resolution number 2.
Of this revised draft resolution number 2, and on that, I turn the floor over to Chair Adam Miigwech.
Thank you, Miigwech, Weena, for reading the resolution in French. So we will now proceed. The resolution has been read into the record. So what I'll do is I'll ask the mover and the seconder if they wish to address the resolution. I will go to microphone number 1. Mover, up to 4 minutes. Go ahead.
Thank you. Khal Salem, chairperson for the Squamish Nation. I want to thank everyone for your time and for being here, for all the chiefs and delegates who have come back today to deal with the important next steps coming out of our decision yesterday and the resounding decision of the chiefs and proxies. This resolution speaks to the desired process that we see as a path forward to getting the final settlement agreement back on track to address the flaws that have been identified by regions across the country and to create a fairer, more equitable, more open, more transparent process for First Nations to be involved in both the negotiations moving forward as well as the outcomes that we would like to see for representation and inclusion of all the regions. This resolution is very lengthy, and I will acknowledge that. But one of the outcomes of one of the reasons we have lengthy resolutions is it's a sign that it was an attempt to build broad consensus across many diverse voices. And so this resolution was written collaboratively by chiefs, proxies, and regional experts from BC, Yukon, Saskatchewan, Alberta, Ontario, Quebec, New Brunswick, and more. We spent 5 hours the other night working on revising both this resolution and the resolution DR04 to incorporate all of the points and ideas and concerns in the process to move forward. The reality of where we're at today is, and it has been said before, we shouldn't have to be here. We didn't have to be in this situation as chiefs and proxies. We didn't have to be in a situation where we had to vote down a flawed agreement and then create a direction to be able to get this back on track. We didn't have to be here. If the process that was used to create the FSA was a meaningful process that meaningfully respected and consulted First Nations, that allowed for meaningful dialogue to improve that agreement, we could have built consensus as a national forum for building a national First Nations political agenda. We could have done that. So this is a lesson. This is a lesson. This is a lesson for the Assembly of First Nations, for the staff and legal, for the advisors, for the portfolio holder who has worked on this file. This is a lesson. The way we got here was not the way we should have done this. There's a better way forward. This resolution speaks to how we can move forward in a good way, how we can work together in that canoe, paddling together to get to that destination. We can hit the ground running on all of the pieces that we need to do to build and fix all the small things, all the medium things, and hopefully the big things that we can achieve to fix this agreement. So I just really want to thank the First Nations Caring Society, all the legal and technicians from the regions who helped contribute to this, to the chiefs and proxies who contributed to this. It was a group effort. We had 50 people in a room working on this for 5 hours.
30 seconds.
And the last thing I'll say is that in discussion with the seconder, as well as the team that worked on this, we know that we are on limited time today to get through the resolutions. So we do not want to entertain any amendments to this resolution so that we can get to a vote as soon as possible on DR2, DR4, and all the resolutions that are on the agenda today. So we are just telling everyone right now, we will not entertain any amendments. at this time so we can get to a vote as quickly as possible. Thank you.
Thank you. Igich. I'll ask the seconder if you wish to speak to the resolution. Microphone number 1.
Oh, Matakia Ben, Ira MacArthur.
Je voulais
The Creator, for giving us another beautiful day, and giving us this opportunity to be able to express our worries, our concerns, our thoughts and our feelings when it comes to our children and our families and our communities. I also want to acknowledge the elders and the ceremonial people that lifted a pipe and offered prayers for us throughout this gathering. That's an important function of us as an Indigenous people. And as we went through the discussions yesterday and in preparation of it, and one of the common themes that I heard throughout all of our discussions was that we all have a great sense of love, not only for our own children, but for everybody else's children as well. And this is something that we must focus on as we move forward, as professional and as technical and as legal as we want to be. We have to focus on the love portion of what it is that we're undertaking as we speak about our children and our families. I want to acknowledge the women of our nations. They're the mother of our nations. I want to uplift and uphold them, in all of the work that they do in our communities, to be able to raise us as men, to be able to raise us as leaders, to be able to raise us to be able to speak in forums such as this on behalf of our nations, on behalf of our children, and on behalf of our coming generations. That's very important when we come to issues like this, to matters that we discuss. A lot of times we forget as Indigenous people, we had processes in the old days. We had processes in our traditional ways, and we had ways that we dealt with issues like this, not only for our own families, but for the families of every member of our nation. And so those are things that we must respect and we must bring to the forefront of our mind when we stand up here to speak, because this is about love. This is about doing the best that we can for our children. And I want to thank the National Chief. I want to thank the National Chief, uplift and show her respect today, wherever she is. I hope she feels well. I hope she feels encouraged in all the work that she's done to bring us to this point. And I also want to make mention of Dr. Cindy Blackstock as well. She's done an incredible amount of work for us, on behalf of us, and behalf of our children and our nations, to bring us to this point as well. And those are things that we have to recognize, we have to acknowledge. As I thought about this, as I thought about all the conflict and the conflicting statements that have been made over the last few days, those two ladies represent our aunties, they represent our grandmothers, they represent an afterthought for us as parents. And this is something that we have to acknowledge, and we have to respect it. We have to honor them, because when they give us their perspective as another form of parent for our children, for our families, their voice and their opinion matters. So I want to also acknowledge all the technicians, the chiefs, the leadership,
30 seconds.
Different professionals that have helped us the other night constructing this resolution. It's difficult at times to be in this spot, but it's necessary because we want the best for our children. With that, I'll say thank you. Aho, Namya.
Miigwech. Thank you, Chief MacArthur. So we have heard from the mover and the seconder. A couple of things, just a reminder in terms of process. What we will do is go from microphone 1 to online and then go in that order. It doesn't matter what order you approach the microphone. Secondly, what I was going to say, I'll go ahead and say it anyway. If you are proposing an amendment, please state that immediately so we can start working on that. Now, just to help expedite and facilitate the timely or the efficient use of time, we did hear from the mover that they are not entertaining any amendments, just to be aware. So with that, I'm going to start with microphone number 1. Go ahead.
Sim gigat sagidam ha nach han kubo sit luam khori un ga asam samal ama Hiluchtun, Colin Sutherland Wilson is my name, Chief Counselor from Kispiox. And maybe I'll just adjust this mic real quick because I'm quite hunched over here. I want to speak in support of this resolution as well as the accompanying resolution DR4. And I also want to share a bit of my perspective coming into this. Because at the end of the day, what I think we all need to be reminded of is we are here because we are winning. 30 battles, 30 victories. And at the end of the day, it doesn't matter which government's in, it's going to be a fight, whether it's liberals, conservatives, NDP. And at the end of the day, it doesn't matter who's in charge, but the truth will remain that we will always be here to fight for the well-being of our children. Going into the Delgamuukh court case, there's a famous quote by Delgamuukh, one of the Frog Clan chiefs in my village. He said, "What is there to fear when you have the truth behind you?" And I think that's an adage that applies to all of us, especially as we make these moves to chart the path forward. The way I see these resolutions, we are strengthening our position. And at the end of the day, we're not here to settle for our youth. We're here to fight for them. And every victory I've seen expands that scope. We're not just talking about on reserve. We're not just talking about the confines of the Indian Act. But across this entire country, you have such a diversity of governments, of opinions, of nations, and we've seen that expressed through the voting. We've seen the need to include all of those perspectives. And even just to share briefly from my perspective as Giksan, we have the principles of Gwalchiens, and we're not going to stop fighting until our kids all have access to that Gwalchiens, which is their inheritance. Because every child has those rights to their homelands, to their culture, to their language, to safety, to homes, to not be poisoned by their environment, all of that. And every time we fight, we win. And so in my mind, if I was Canada right now, of course I would want to cap off the progress because they see it's a losing fight. They see they cannot win against our desire to protect our children and to uplift them. So I just wanted to state from my perspective, together we are strong, we're unified, and as we move forward, they need to know that we're here and we will always fight for our kids. And we're not just asking for the bare minimum, that they're on the hook, that they are liable for acts of genocide, and we're not going to let them off easy.
30
Sabah.
seconds. Microphone number 2.
Kelsey Natchez Houché Godri through Chuktwe, Chief of Cold Lake First Nations. I'm in support of this bill. I just want to give thanks for the technicians and the people who worked on this. I seen the bill, the resolution change. I was going to do some amendments, but they already did it for me, so thank you for that. But I just want to comment on number 12, to direct the AFN Executive Committee to postpone any votes on the LRTR agreements or any other agreements until all First Nations have at least 90 days to review the complete agreement appendices available in both languages. Yeah, it's kind of hard, We're losing our languages. It'd be nice if we had translators for all our languages here, It's a lot of times explaining and whatnot, but, we should move in the future to have all our languages here at this assembly. But I don't want my brothers to be left out in Northwest Territories. I don't know why they were left out of the final settlement agreement, Like in 1905, my band was considered a rebel band, the making of Alberta. Before that, it was considered Northwest Territories. That's discrimination when you're leaving out my brothers and sisters. The Dene, We're a country within a country. So when you talk about this moving forward, it's a very tight timeline, 90 days. But these are my brothers and sisters, so don't leave them out of this process. You talk about unity, well, let's do it. Masi Cho.
Rich, thank you. I'll go online now. Chief Byron Lewis. Go ahead, Chief Lewis. Oh, we can see your lips moving, but we can't hear you.
Okay, I thought I touched that. There we go.
There we go.
Byron Lewis, Chief of the Okanagan Band. I'd like to propose a friendly amendment just to avoid any legal complications. And that's under governance and transparency, Art 2B. And I'd like to put in there after pet C, after the Chiefs Commission, if matters arise with respect to replacing the negotiating team, that all previous contractual obligations and benefits will be honored. And that's just to avoid any legal complications. I've been, around since 1991, and, I'm a little nervous when it comes to legal matters, and especially under contract. But that's what I'd ask for, a friendly amendment. Okay, thank you.
Thank you, Chief Lewis. So what I'm going to do is I'm going to ask Encore to open the Google Docs drive and put it up on the screen. There it is. There is a request for an amendment. I will go through the process. I'll confirm with the resolutions team that they have the amendment. Once we have that, I will read it. I will confirm with the requester of the amendment, and then I will go back to the mover and seconder of the resolution to see if they agree with the amendment. So we're just doing that up on the screen, and we have a copy up on the screen, and I just want to make sure we see it. Chief Lewis, can we just confirm where you would like the amendment? You're still on mute.
That's under governance and transparency of the LTR agreements, and that's under 2B.
2B.
Yes.
And can you repeat the request, the text?
Yeah, it's under B, it would be if matters arise with respect to replacing the negotiating team, that all previous contractual obligations and benefits will be honored. And that's just to avoid any legal complications.
Chief Louis, sorry to interrupt. Are you asking for that at the end of that paragraph?
Yes, either just immediately after that, create a C, or add it to that existing paragraph.
Okay, so either at the end of the existing paragraph or a new paragraph. Thank you. Just
yeah, so I can be a new yeah.
Okay, stand by. And it'll take a minute here for the resolutions team just to make sure we get the proper text of the requested amendment. Let me know when you're ready. Okay. So we're just making sure we have it correctly. We see some version of it on the screen, but they will advise me once they are ready. Miigwech kadinawa mga sa jibedamik magyabits kadanabik chigeguniga gadasn chigadik. So again, thank you for your support, your patience, while we sit and have these important discussions. So Chief Lewis, if you can look at the screen and if you can confirm if this is what you're asking for, what it says is C, if matters arise with respect to replacing the negotiating team, that all previous contractual obligations and benefits will be honored. Is that what you're asking for? Okay.
Yes.
Thank you. Next, I'll go to the mover and seconder if they agree to the amendment. Mover, microphone 1.
In conversations with the seconder, we don't agree to the amendment, as that matter would be addressed administratively by the AFN Secretariat and is not required for this resolution.
Thank you. So the mover and seconder do not agree to the amendment. Thank you. So I will move along, and what order was I at? Okay, microphone 1. Go ahead.
Hi, it's Phyllis Hudson, proxy for Chief Aaron Sock of Osibuktuk First Nation, New Brunswick. Today I wanted to take a moment to acknowledge 2 warriors now in the spirit world, Mr. Harry Sock and Mr. Gary Sakobi. And for Gary Sakobi's vision for the First Nations Caring Society. These 2 very great warriors set the foundation to community-based agencies in the province of New Brunswick 41 years ago. I want to acknowledge and celebrate the essential role of First Nations social workers in our communities. These dedicated professionals are more than just social workers. They are healers and cultural guardians who are deeply rooted in the traditions, values, and history of our people. First Nations social workers bring an own new perspective to their practice. They understand the deep connection between culture, identity, and well-being, and they recognize the impact of generational trauma and systemic inequalities that our communities have faced. With this understanding, they offer more than just support. They offer a path to healing that is respectful, empathetic, and culturally receptive. Every day, they work tirelessly to address issues that affect their communities, from mental health and substance use to child welfare and housing instability. They help families navigate complex systems, advocate for resources, and most importantly, they listen. They listen to the voices of those who have been silenced, and they amplify their stories, ensuring that the unique needs of First Nation communities are heard and met. Their work goes beyond providing services. They are the ones to help to preserve and promote traditional knowledge, languages, and practices. By incorporating these elements into their work, they foster a sense of belonging and pride within their communities. They are essential because we know that strong cultural connections lead to stronger, healthier communities. The challenges they face are not small. They work in environments that are often underfunded and under-resourced, yet they continue to show up every day with a commitment to making a difference. Their resilience and strength are a testament to the power of community and the enduring support of our people. As we reflect on the contributions, let us also think about what we can do to support them. This means advocating for better funding policies and resources that empower First Nations social workers to continue their essential work. This means acknowledging and addressing the systemic barriers that still exist. And it means listening to and learning from Indigenous communities so that we can work together toward a future where everyone has the opportunity to thrive. Thank you to all First Nations social workers for your unwavering dedication, your compassion, and your courage. You are the heart and soul of your communities, and we are deeply grateful for everything you do. Thank you.
Thank you very much. At this point, reminder, we are not rushing this discussion, but we are over our time allocation. So I will close the speakers list with those that have already approached the microphone. So 3 more here on the floor. So microphone 2.
Thank you, Mr. Chair. Chief Dan Manuel, Upper Nicola Band. I want to thank the mover and seconder for bringing this resolution for discussion. I'm going to speak in, I have some real concerns. And I know you're not entertaining amendments. However, I want to be on the record to express some of the concerns that I've discussed with my decision makers, the Kustim Tima, who I remind the mover, who has expressed a notion that we must be informed. I started at the very same place as all the chiefs here in Assembly in July, and I arrived here ready and fully informed and fully mandated by my community to support this agreement. because as the mover has expressed, this is important. This is critical. Our children are sacred. In July, I left Halifax. I read this agreement on the plane between Halifax and British Columbia. Before I left Halifax, I presented that agreement to the Kustemtima, the decision makers in my community. And we met and discussed this tirelessly. We brought our community together. So when we talk about being informed, I have a responsibility as a chief. In my language, Yilmikwam. It's my responsibility not to come to this mic uninformed. If I stand here before you and speak, I have to be informed. So I wish to impress upon you when we embark on this process, as you've expressed a willingness to create consensus, that willingness was not shown to me by yourselves, the mover and the seconder, and others who are supporting this resolution. I made it known that I was available to try to seek consensus. Yesterday on the floor, I asked for us to come to consensus. A specific issue I have is related to the inclusion of the Child and Caring Society in the working group. The Child Caring Society is a party to a legal dispute being heard before the Canadian Human Rights Tribunal. In order for them to be participants in a process, it's not up to the AFN, it's not up to the chiefs in assembly here to direct the Canadian Human Rights Tribunal to accept, and any discussion with the Child Caring Society will require, I would gather, some legal release from the tribunal to allow them to the table, unless they're going to re-enter the negotiations. And if that is the case, it should be clear in the resolution.
If you can conclude with one sentence, please.
Thank you, Mr. Chair.
Thank you, Chief. Miigwech. Microphone number 1.
So Chief Don Harris from Douglas First Nation in BC. When I came to this session, I was undecided, but after going through the reading yesterday and some of the amendments, one of the things that affects my community is the inclusion of the treaty rights in there. You know, I have nothing against treaties, but the modern day treaties really affect my community. You know, 10 years ago, we battled one of the treaty groups that overlapped us to the point they no longer exist. One of the main issues was child and family, because they had child and family written into their final agreement that overlapped and claimed 100% of our territory. You know, and I was glad to hear that the mover and seconder were not going to entertain any amendments, because that's what changed my mind yesterday, is that by adding in the inclusion of treaty and how they would affect, we have enough issues that hinder our progress as a community. Like, we are non-treaty. We have no self-governing agreements, nor are we negotiating any. And I still have 10 overlaps. I think that my community is the most overlapped in BC. We have a couple of more treaties that overlap us. We have some reconciliation agreements that overlap us, and numerous revenue sharing agreements that overlap us, and majority of them overlap us by 100%. And by having the child and family issues dictated by some of these treaty groups, like I said, is that the one treaty that overlapped us had one of their key articles was child and family, and they would have basically controlled our children if they step over the reserve boundaries. So I just wanted to share that when the negotiators are moving forward, you have to remember there are still non-treaty communities. I know we're becoming a minority now, but the governments do tend to use whatever agreements in place to continuously try to eradicate the non-treaty communities. So, I'm hoping that we can get this moved forward, and hoping that we can keep it where it is fair to everybody and includes everybody, but doesn't allow others to hinder other communities because they are non-treaty. Thank you very much.
Thank you very much. So I had already closed the speakers list. Final speaker at microphone number 2, but I do see a hand that has been raised online. So what I'm going to do is go to microphone number 2 and online, if it can be very brief. I'm told it might be very brief. So I'm going to go to microphone number 2 first.
Okay. Good morning, everyone. My name is Erica Bowden, Chief of the Cowes First Nation. From Treaty 4 territory. We are the largest First Nation in Treaty 4 territory. Our claim to fame, so to speak, other than living on God's land, is being the first band or the First Nation to sign C-92, and we are currently the first First Nation that is in negotiations for a successor agreement. As such, we have been very closely looking at exactly what the long-term reform looks like, how it would impact, and exactly what the connection is. I want to say first and foremost that we support this number 2 draft resolution without any amendments. We recognize that there have been hundreds of hours spent on what we defeated yesterday. However, there's been also hundreds of hours and hundreds of minds that have worked together in order to have something that is not only grassroots, but for the best for our children, families, and communities. And I have great hope that all of us could work together, whether or not it's on long-term reform or Bill C-92 or whatever the case of legislation is for the best well-being of our children. I have 2 comments to make, but before that, one of our matriarchs, Regina, Ms. Regina, asked me to ask a question, who are the Children's Commission? So I will just leave that there. But as we move forward, we do have a short timeline. The good news is that we have a lot of strength to work from, not only the work that was done by the AFN, but also the incredible work that was done by our technicians, our chiefs, our children in care, former children in care across the country that are ready to roll up our sleeves and continue the work. Our job as chiefs is not only in that technical perspective and to have that consensus and knowledge within our First Nations, but to use our positions as chiefs of sovereign nations to pressure and to inform the government, not ask the government, but to talk with Premier or Prime Minister Trudeau, Mr. Singh, Mr. Poilievre, and affirm that our children are not a specific claim. They are not cows and plows. They are not a commodity. They are the essence and the bloodline of our ancestors and the future of who we have always been. So I encourage all of us as chiefs, as we knock on those doors and we prioritize other matters, that this is directly linked to the future, the well-being, the sovereignty of who we are, our children, and we maintain and keep our children at the top of that list as we keep other priorities as well. Mr. Singh, Prime Minister Trudeau, Mr. Poilievre, we are here, we are not going anywhere, and we will always place our children first. Thank you.
Thank you very much. And what I will do is, I had closed the speakers list, but a hand has been raised online. And if we can be brief, please, Chief Nicole Tom.
Masicho keme sothan, danyeti here sothan detsi uji. I just want to thank everybody on the floor and who is actively advocating for our children and our families. I would just like to confirm quorum. We haven't heard that yet, and if the Resolutions Committee could provide that for us. Merci.
Thank you very much. So the request is to confirm quorum. I can confirm that when we started dealing with the resolution, we did have quorum, and we've just checked again. I'm going to consult with my colleague. We do have quorum. Yes, we do have quorum. Thank you very much for that request. So we can proceed. So with that, we have had discussion, debate on the resolution before you. We are dealing with draft resolution number 2. So I will call for a question. What I'm going to do is online, if we can have the polls please opened. If we can please open the polls for those online. The polls are open. In the room, the resolution is before you. Any opposition to the resolution, please raise your lanyard. Any opposition? And we'll have the team count. Any opposition to the resolution? I'll just take some time here and wait for our team to get confirmation of when we can move on. Thank you very much. In the room, any abstentions? Any abstentions? Please raise your lanyard, red lanyard, and we will take some time. I see one that's raised at least. Just a reminder, you need to raise it high and keep your lanyard raised. Thank you. You can lower your hands. All in favor, please raise your lanyard. The way I would say it in my language is awanen gawid gabawitang kumbentketan. Which literally translates back to English as those who stand with it, raise your arm. Thank you. You can lower your arms and close the polls, please. Polls are closed online, and I think it's fairly obvious, but I'll just wait for confirmation officially. Sometimes there's a difference in the room and online, and there's quite a significant number of chiefs online. So I will wait and officially let you know the results. Ego jikendamik gaun ego gegon mijim aptagizgach mi buga no magay abyacht nego achat zakishman ega we bajgistuik. Just a reminder while we're doing that, that the agenda actually called for us to conclude the assembly before lunch. So lunch is not provided. There is no meal for today. Just to remind chiefs, you're on your own for your meals at lunchtime. Again, or you can start fasting like some of us. Again, just waiting for the official the official results from the voting. Again, just to be mindful of the time, we are over on the agenda. We had hoped to start the closing protocols, which again is very important as we close the assembly. We do have another resolution, draft resolution number 4, and it is 12 minutes after 11. After this resolution, what we propose to do is to continue on to move to draft resolution number 4. But again, we need to be mindful to expedite and efficiently use the time that we do have and come to a decision on the next resolution. But we're not there yet. We are just waiting on results for this current resolution. Is it dealing with this resolution? Sorry, microphone 2.
We're just wondering if we can address a point of order while we're waiting.
Okay, point of order is important, but we're just in the middle of this, so I will come back to you. Thank you. So the resolution before you, those in favor, 186. Those opposed, 7, and 10 abstentions. So the resolution is carried. Thank you. Now, I will come back to microphone number 2.
Rashish, ING UNSCU Kuchanke Sean Smith Kwanlandan Natheda Ijeshu. So I shared, I am the Chief of Kwanlandan First Nation from Yukon, and a respective delegation of Yukon First Nation chiefs, as well as we're accompanied by our relatives across the Northwest Territories border to join us in sharing this point of order. So AFN meetings require professionalism and decorum. We all have responsibility to ensure that these events are safe for all participants. Yesterday, Chief Wilfred King disrespectfully challenged our co-chair, Weena. His comments, tone, and delivery were incredibly demeaning and wholly unacceptable. Simultaneously, there were efforts made by chiefs on the floor to have our male co-chair take over, which was again very disrespectful. On December 2020, we passed AFN resolution number 13-2020, becoming a role model in ending sexual orientation and gender-based discrimination within the Assembly of First Nations. We failed this commitment to be a role model yesterday. Further, the AFN Code of Conduct for events is clear that this behavior is inappropriate. In the past, when a participant who happened to be a woman behaved in this way, in the way Chief King did, she was removed from this assembly. Remedy is required, and we must hold each other to account, as a code of conduct is only as powerful as its enforcement. Chief King, a public apology is required. Otherwise, it is our view and interpretation that you should be removed from speaking at this assembly, as has been the precedent in the past. Finally, the updates proposed for AFN Resolution Number 13, 2020 must be brought to the December 2024 Special Chiefs Assembly to be updated and formally accepted. To share personally, since 2014, since I was elected to council within my nation, and coming to AFN events, almost every single AFN event, I've seen quorum and how people treat each other in a not a very good way. As a younger leader, is this what we're showing to our, or as a leader within this assembly, are we showing our younger leaders how to behave and how to treat each other within these discussions of importance? I know things get to really, really heated, and to a certain point, lots of different things, lots of different feelings from the past, current, and the future, of course. But this is a point of order that I'd like to share as part of our Yukon delegation, accompanied with our Northwest Territories delegation.
Thank you very much. I would like to acknowledge the chief that approached microphone number 2. I know he's in a discussion, but I have some clarifications. I take your point of order. A point of order is a question on procedure. And I see your statement that you have made as also a statement, a broad statement, that we need to respect each other and follow the code of conduct that each one of us has signed. So that's what I see as a statement. I just want to clarify, when we are posed with a point of order, it is a ruling or a procedure that we have to follow or consider following. That may not be the right word, but my question is, in terms of point of order, you have made some recommendations which will be taken back for future assemblies, but I think more importantly is that we have to be respectful of each other, regardless of gender, male, female. So my question is, there was also a point of order. Are you asking us to take that into consideration of removing a chief for the remainder of this assembly? Or is it more of a statement? I just want to clarify, you called it a point of order.
Yes, that is the whole point of the order in terms of the procedure of the AFN Assembly. You know, unless there's a public apology to INA.
Thank you. Thank you. And again, procedure in terms of points of order is that the co-chairs consult So we take a majority of what you've said as a statement, a strong statement in the Assembly, and also in terms of the request for a public apology, we take that. Of course, it's not something we can impose. We have control of what happens here in the Assembly, but outside, something we have no control over. So we have taken your request into consideration, and we accept the recommendation and the decision that he will not be speaking for the remainder of this Assembly. So, miigwech, thank you. I will now go to microphone number 1.
Thank you. And thank you, the delegation and the young leader, to call us on this. I think that's just wonderful, and really, I know we're in good hands when I see young leaders like that. My name is Mary T.G. Mausham Gabu. I am Takla Nation. I'm also, I come from the Lachgibu clan, the Wolf clan. Denize, Tsekuze, Schaize, Samoget, Simhanach, chiefs, leaders, delegates, and youth and children that may be watching. I'm so honored to be here today, and I really apologize, but I do have to leave right away after this. I just wanted to say thank you all and to remind everybody that today is a day of dreams. These resolutions 2 and 4, I support resolution 4 that's coming up because it's about fair process, it's about fairness and justice. I believe that the clearer we are about problems, the better solutions we come up with. I believe that when we come together and we talk about those challenges and we say this is what's wrong, we come up with our minds together to get better solutions. We heard the chiefs all of these months that chiefs didn't want to support the draft FSA because it did not have their voice and they felt that there was no free, prior, and informed consent. We heard that. We heard that this agreement did not reflect our principles of love and inclusivity. We heard that. So across there's 50 people there, we made sure that there was allowances for those ones that did not have a voice in Alberta, that those children were not left out, that Northwest Territories children were not left out. Because as my CEO always says, a child is a child is a child. And I believe that we came together to get the best solutions rooted in love, compassion, and responsive to the needs of our nations and to our children. In 2005, great minds came together in Niagara Falls from all over the world, and what they were looking at was the overrepresentation of children in the foster care system. So everybody came together, and what we developed at that time was a pathway forward for reconciliation and child welfare, and that was called the Touchstones of Hope. One of the leaders of that was Cindy Blackstock in 2005. 2007, this one young, courageous woman, back then very young, took Canada to court, even though people said it couldn't be done. Over the last few days, I've been hearing, oh, we can't do this, we can't do that in an agreement. I think we've proven that we can do it. 30 challenges, 30 wins. I just wanted to say that because I think when we all come together and we're all there for the best solutions, these resolutions, I know they were long, but it came together to really address the challenges that we had with the draft FSA. So thank you for your support, and thank you for all the technicians that were part of this. Today, there are no winners or losers. Today, the only winners are those children. And we know that, and we've come together. It's not about us. It's about our children and those that we have lost. Today, we're all part of history, and we are all part of the beginning of the work that we need to do to make history for a new generation of young people who may never have to be discriminated against. I'm going to leave you with words of a former child in care.
30
he
seconds.
was 12 years old when he said, I dream of a day when I don't have to feel the impacts of residential school. All I do I'll just read about it. We today made that dream so much closer. Lastly, I just want to remind you that you are the ancestors of those not yet born will speak of. And what will they say? They will say, thank you, and you did good. Peace and love, Masai.
Thank you very much, Proxy TG. I do see at microphone 1, but I would like to respect the movers and the seconders of the next resolution, and very quickly, because I know chiefs are leaving. So I'd like to, as soon as possible, get to the next resolution. So microphone number 1.
Thank you. I just have a quick suggestion for the co-chairs to expedite our process for the next few resolutions if we can get through them. The resolutions have been handed out and everybody's had copies for at least 24 hours. So I'll just make a suggestion, if the co-chairs would entertain it, that we just do the reading of the therefore it be it resolved sections. The whereases can be read, but we go directly to the therefore it be resolved sections so that we can expedite the process, because it took us 25 minutes to get through the last resolution just reading in both languages, so I'm hoping we can make it a little bit quicker. Thank you.
Thank you. We'll take that under consideration. So at this point, what we will do is get into the next resolution. So if I can have up on the screen draft resolution number 4, please, and I'm just going to take a second here before we get into it. Thank you. So what we're going to do is everybody does have a copy of the resolution. It was handed out yesterday. There have not been any changes. It is available online, so we will read only therefore be it resolved. Also, I will read it only in English. And I just want to confirm before we decide not to read it in French that translation is working. And I know sometimes I read it slowly, but I may read it a little extra slowly, just to make sure that the translation happens properly. Is the French translation working? I want to get that confirmation. Can I get the thumbs up from translation? Thumbs up meaning it's working? Okay, very good. So French translation is available. So we have draft resolution number 4. The mover is Proxy Judy Wilson, who I saw previous. Oh, there you are. Thank you. Seconded by Chief Carolyn, and I apologize in pronouncing the last name, Wahaban. Chief Carolyn Wahaban. Seconder of the resolution. Are you in the room? And again, I am looking for the seconder, another call. If she's not here, what I will do is ask for another seconder. I see a hand. She's online? Okay, thank you very much. Thank you. Thank you again. She is online. The seconder is online. So we have the mover and the seconder present. So we have Chief's draft resolution number 4. It's titled Meaningful Consultation on Long-Term Reform of First Nations Child and Family Services. Mover and seconder are present. I will go to the bottom of page 1. Therefore, be it resolved that the First Nations in Assembly. Oh, reminder, French hard copies are available. It's also online, and the translation is happening as we speak. Therefore, be it resolved that the First Nations in Assembly, 1, reject the draft FSA on long-term reform of the First Nations Child and Family Services Program dated July 11, 2024, and the proposed amendments of the draft agreement on long-term reform released on or about October 7, 2024, and direct the Children's Chiefs Committee as defined in the AFN Draft Resolution 02-2024 to renegotiate the draft FSA in keeping with the directions of First Nations and Assembly, including but not limited to A, amend and propose and associated text of the agreement to clarify that the agreement is intended to hold Canada accountable to stop the discrimination and prevent its recurrence. B, restore First Nations chiefs as the key decision makers on long-term reform. C, expand the principles to include honor of the Crown, Canada's responsibility to fully end discrimination and ensure it never happens again. Intergenerational equity, transparency, accountability, and inclusivity. D, make governance of long-term reform transparent and accountable to First Nations chiefs. E, incorporate ongoing and meaningful oversight by and consultation with the National Advisory Committee on Long-Term Reform of the FNCFS program. F, preserve the mandate and independence of the Expert Advisory Committee to reform ISC. G, expand the scope and strengthen the role of the Dispute Resolution Tribunal and ensure the remedies available to the Canadian Human Rights Tribunal are also available to the Dispute Resolution Tribunal. H, strengthen the regional modifications provisions to align with the CHRT orders that First Nations children must have access to and receive needs-based, substantively equal, culturally appropriate services that account for the distinct circumstances of their communities. I, ensure that the definition of First Nations child as defined in 2020 CHR 36 is considered and incorporated into the FSA. J, ensure that prevention funding is allocated as follows. 1, to First Nations to develop and deliver prevention programming in line with their self-determined service delivery models, and 2, to FNCFS agencies to ensure they can deliver prevention in a substantively equitable manner in keeping with legislative requirements to meet the needs of First Nations children and their unique cultural circumstances. K, ensure there is an evidence-informed, needs-based funding structure that is responsive to the distinct circumstances and needs of First Nations children and their families, and can be upwardly adjusted to address those needs and circumstances on a First Nations, regional, or sub-regional basis. L, ensure there is a region-specific, independent First Nations-led technical secretariat for each province territory. M, ensure that Canada puts in place sufficient liability coverage and statutory immunity for First Nations and FNCFS agencies in relation to the services they provide, and ensuring that Canada will be the insurer of last result for First Nations and FNCFS agencies that have exercised good faith decision-making. N, ensure that Canada discloses all federal, provincial, territorial service level agreements during the negotiation process and consults with those affected First Nations throughout the negotiation process. And O, ensure the CHRT retains jurisdiction over implementation of any FSA. 2, call upon Canada to obtain a new negotiation mandate to address the matters in this resolution. 3, direct Canada to fully implement the funding principle of predictable, stable, sustainable, needs-based funding in the form of unconditional grant, consistent with the principles of substantive equality and cultural continuity in line with the CHRT orders to secure long-term positive outcomes for First Nations children, families, and societies. 4, direct Canada and the AFN to refrain from bringing any motions or seeking direction from the CHRT to set aside existing CHRT orders, including but not limited to 2018 CHRT 4, 2021 CHRT 41, and 2022 CHRT 8, without the prior approval of First Nations in Assembly. 5, direct the Children's Chiefs Commission to ensure that any FSA does not abrogate or derogate from First Nations title rights, treaty rights, or in any way limit or diminish Canada's duty to consult, fiduciary obligations to First Nations, or the honor of the Crown. So that's the resolution before you. Mover, microphone number 1 to speak to the resolution.
Judy Wilson, proxy holder for Skyloch First Nation. I just wanted to say the resolution includes all of the regions and all of the chiefs and proxies when we met a few days ago to have an inclusive, substantive resolution today. So I'm not anticipating any amendments. I will not entertain any amendments for the mover or seconder as well, because time is also a factor. Many are catching flights today. I just wanted to speak to one issue because it kind of raised a question to us in the last resolution was there is no exemption required from the tribunal. The AFN is also a party to the tribunal, and all parties, including AFN, are free to participate in negotiations to try to address the discrimination. So I just wanted to clarify that because there was a question, I think, from Chief Dan, if he's still in the room, about conflict of interest. And I didn't think that was standing either when they were discussing it last year or earlier this year either, because they were calling Caring Society a conflict of interest when the AFN was also a party at the table. But I know the Caring Society had to go on to do another Canadian Human Rights Tribunal thing. But I'm not going to go into those discussions. It's just, I think the resolution speaks for itself. And there was many, many people that worked on it till really late in the night and the last few days. So I want to extend my appreciation to all of those that contributed to it and the work that was done here, and share the sentiments that were expressed by Mary TG and Cosalem that, you know, this is not the closing of it or rejecting of it. It's the work that we're doing to continue, that we do have the Canadian Human Rights Tribunal orders, and we're building upon them to move forward to make sure that the chiefs have a say in this, and they're directing it, and they're also that the experts and technicians are also included in this process. And that's what a lot of the fundamental things were not being addressed in the last, you know, the amended FSA. So that's all I'm going to say, and I don't know what the seconder does. I'm kind of pressed for time, so I'm hoping we just go right to a vote right after this close. So I'm not going to do any amendments. Thank you.
Thank you very much. So I'll go to the seconder who is online.
I know everybody's pressed for time there, so I agree with the mover there, and we'll just get on to the voting because I do support this resolution. So let's just do that. Thank you guys. Thanks for everything and all the work that you guys do and helping us, the technicians, the elders, all the supports that have been guiding us along the way. I appreciate it. Thank you.
Thank you very much. So the floor is open. Microphone 2.
I guess is it afternoon? Whatever. Good day. Regina Crow, Child Suited in a Nation. I support the resolution. The only question I have, I know the FAS mandate just includes on reserve, right? And I'm just concerned about the off reserve because we have children, families that live just across the street and they're looked at as off reserve. Because of our lack of housing, we cannot keep up with the housing requirements. So I'm just wondering what can be done. Can it be included in this resolution, or what can be done for those children off reserve? Because all our children matter to us, and we look after them the best way we can.
Thank you very much. So there is a question, and there's a question, and then there's sort of a recommendation, I think, for an amendment. So I'm not sure who the question is targeted to. I have thoughts on that, but I'm not in the position to answer the question.
Well, it'll be the mover and the seconder.
So I'm looking to the mover. Thank you.
The issue is under the old FSA amendments, there was a narrow mandate from Canada. So we are going to get a broader mandate, and also there would be inclusiveness because there was we were only talking about on reserve in the other one. In this one, we want to talk broader about the ones off reserve as well. So we want it to be more inclusive.
Microphone 2.
Yeah, I accept that, but I thought if it was written in there so that Canada doesn't say, no, the original mandate is on reserve. So it's clear that we're looking at that and trying to include them. That's all I'm asking for.
Thank you. Back to the mover at microphone number 1.
I'll just be more specific then. Under therefore it be resolved 1I, it says ensure the definition of the First Nations child as defined in the 2020 CHRTC 36 is considered and incorporated into the FSA, which has already been a ruling from the Canadian Human Rights Tribunal order that needs to be in this. Yeah, that wasn't in the other one.
Okay, thank you. Okay, next speaker, microphone 1.
Thank you, Skulitzelton, Bill Yoakum, Sinemo. I just want to first of all thank the two co-chairs. It's been a tough few days and tough subject, passionate all around. You guys did an amazing job, not easy, so we lift our hands up to you. And just want to state the hard work. Everyone working the other night till midnight-ish, some till 1, and the whole intent is bring everyone together at 1. There can't be no winners and losers, and I believe we came out of this where everyone's going to win, will win, because we have to win, and it's going to happen. It's great work by everyone, and I'm not how sure the procedures work, but at this time I'd like to call question. Hi, Sepka, thank you.
Thank you. So the question has been called. We'll take that under advisement, but we do have at least 2 speakers at the microphone. So we will go to the next speaker, microphone 2. Go ahead.
Gala Kessler. I'm Clarko Gala. I'm a hereditary chief for Muchlet First Nation. And I just want to ask if it would be okay in whereas B to include hereditary chiefs, because it says only elected chiefs. Because my daughter is online, Melissa Jack. She's proxy holder for hereditary chief Jordan Michael. And I think it's really important to add hereditary chiefs, and it's just a minor little thing. And as I want to thank our friends from the Yukon and for everything they did for you two. I have utmost respect for you, Co-Chair Adam and Co-Chair Weena. Thank you so much for what you do for us to keep us going in a good way. Kleko, kleko.
Thank you very much. So the request is a friendly amendment to include hereditary chiefs. With the request for an amendment now, I'm going to ask Encore to open up Google Docs and put up the version that is changed. Once we have that, I'm going to, there it is, mover.
It's in the self-determining of the nations. They define who their leadership is. We didn't want to define it for them. So I did speak to Chief Jerry Jack and Chief Don Harris on that point. And so the intent of the resolution is the nations will decide who their leadership is. And, but I didn't want to do any amendments because it's going to cause a lot of time here. And I would respectfully say I feel it's in the resolution already. And the spirit and intent, because I work with a lot of hereditary chiefs across Canada, and I do respect their leadership. So I just wanted to say that. Thank you.
Thank you. So the request for an amendment is not agreed to by the mover. The feeling is that it is already there in spirit. Thank you. So with that, next speaker, and I am looking around the room, I'm looking online here in the room physically. So we have 1 speaker, and with that, I will close the speakers list. So final speaker, microphone 2.
Hey, how's it going? My name is Quanah Vandermeer. My Upper Canada name is Nanisha, which means to return. I'm chief proxy for White River First Nation in the Yukon, one of the 3 nations in Yukon who have not and will not settle land claims or self-government agreements. I just want to make a quick statement. It was quite disheartening to see so much division in our people yesterday. Today is much more beautiful to see us come to an agreement. We all bleed red. We are all one. We're in this for the children, and the children always come first where I'm from. And I want to add, I support this resolution because the definition of a First Nations child under 2020 CHRT 36 is the definition that I fully support. Sini to the mover, seconder, and the co-chairs. Thank you.
Thank you, and thank you, everyone. That concludes our discussion, questions, debate on the resolution. So with that, I'm going to call for a question. If we can have the polls opened online, please. If we can have Encore open the polls online. The polls are open. You can vote online here in the room. The resolution is before you. Any opposition to the resolution? Any opposition? And sorry, I think I didn't warn our team, our counters, that we were going to go to the vote. So they're just getting ready. Any opposition to the resolution before you? Thank you. You can lower your lanyard. Any abstentions to the resolution before you? Any abstentions? Thank you. You can lower your lanyards. All in favor, please raise your lanyard. Thank you. You can lower your lanyards. And again, I think it's fairly obvious looking around the room, but I'll wait for official word and give you the official count. If we can have the polls closed online, please, and then we will come up with the final numbers. If we can close the polls online. Thank you. Thanks. While we are waiting for the official results, again, looking around the room, I think it was fairly obvious. Just to let you know, in terms of process, what's happening next, we did not finish with all the resolutions. So I'm going to read this out just to be clear, because we will not be able to deal with any of the remaining resolutions. It is now 10 to 12. We are beyond our agenda allocated time to conclude the assembly. So just for the record, I'm going to read this according to the rules and the procedures for Assembly of First Nations assemblies. If the allotted time for resolution debate and voting expires, the session will be closed unless a majority of chiefs and proxies and representatives present vote to extend the allocated time. Here's the important part. If the resolutions do not get debated due to time constraints or lack of quorum, the chairpersons may refer the draft resolutions to the next AFN Executive Committee meeting with recommendations for their consideration. This information has been shared with the movers and the seconders. The next SCA is planned for December 3rd to December 5th. So just so that you're aware, that is the process if we're not able to deal with all resolutions. I see a microphone, I see you, but I want to get the number and then we'll finish that and then I'll come back to you. So just to clarify, I was reading that process, and what happens is we will defer resolutions to the executive committee for their approval. That is normally the process. Okay, so coming back to draft resolution number 4, those in favor, 179, 4 abstentions, and 6 opposed. So the resolution is carried. Thank you very much. Microphone number 2.
Hi, Isaiah Bernard, proxy for Chief Wilbur in Blue Lake First Nation. First and foremost, I want to apologize to all the BS you had to pull up for the last 2 days as the co-chairs. I'm sorry. And second, I want to make a motion to extend the agenda by an hour. Hopefully you guys won't kill me because I did it yesterday and I got a lot of death stares. Just saying. So I'm looking to make a motion to extend the agenda by at least an hour.
Thank you. So the motion on the floor is to extend the agenda for another hour.
Yeah.
I'm looking for a seconder. Is that what you're proposing? Microphone 1? Go ahead.
Yes, Nistuakok Makinima, and I second the motion.
Thank you. So there is a motion on the floor to extend the agenda for another hour. So what I will do is I sort of need some text, not sort of, I need some text for the Encore technicians so that we can open up the polls online. Again, this is your decision, this is your assembly. I know many chiefs have made travel arrangements. Many have had to start their travels. But this is your decision whether you wish to extend by another hour. So I'm looking at the clock here. That's 11:53. That would take us to 12:53, but that includes probably 30 minutes of closing protocols as well. So, 2 things first. We need to confirm that we have quorum. We did confirm previously when we dealt with the resolutions that we did have quorum. In order to entertain the motion, we need to make sure we have quorum so that we can vote on the motion. I said 2 things. What was the second thing? The second thing is we will get to the motion. Oh, second thing is we are waiting for the language to be put up on the screen. Do you have any text? It's there. Oh, it is there. Okay, thank you very much. I can't see it, but, right over here. The motion is to extend the agenda for 1 hour. And again, that would take us to, it's now 11:54. That would take us to 12:54. But to be mindful that we need roughly 30 minutes for the closing protocols. Are you ready with the poll? Online? Oh, we need to confirm quorum. We're doing that right now. And thank you for bearing with us as we confirm quorum so that we can entertain the motion. Thank you. We're just doing the confirmation as we speak. So we do have quorum. Thank you. So the motion is on the floor. Can you please open the polls online? The motion is to extend the agenda for 1 hour, being mindful that it will take 30 minutes for the closing protocols. Polls are open online, in the room. So I just want to explain how this is going to happen. I'm going to ask any opposition to the motion. And if you are opposing the motion, that means it's time to wrap up and we go into closing protocols. So, any opposition to the motion, raise your lanyard. And that means it's time to wrap up. Opposition to the motion? I'll emphasize again that that means it's time to wrap up and begin the closing protocols. Please keep your lanyards raised, please. Thank you. Also a reminder, while we're doing that, there is no meal prepared for today, so you're on your own for lunch. Or start our diet for the weekend. We're good? Thank you. You can lower your hands. Any abstentions? Any abstentions to the motion? Raise your lanyard. Any abstentions? Thank you. So, next one is all in favor to the motion, which means extend the time allocation to continue discussion. Raise your lanyard. Thank you. You can lower your hands. So again, it's just going to take a little time to confirm the numbers on the motion to extend. If the decision is not to extend, what we will do is conclude with this portion of the agenda, at which point I will hand it over, make some comments, and then adjourn, and then hand it over to my colleague to start the closing protocols. Mi webin magikidyan nananako migwits nindan guys segma juit chinaguk majuga giatsto yanaman eskam papakanga inisgadek doesn't ganunk eska majuga musto yak exige one gadazminda abnonjisak ego das kino agot sa yun danawa yo kaugmawi kaugma kani tamage tengakit kino kani tamawai kedan shnimwa mauje kuzuwendago kyo kedan kino agot migwets kedanawa kyabich magayaik. So I was just saying in my language, I know that this has been a very heavy discussion. It has been very emotional at times because I know that as leaders for your people, you are very passionate for your children and you are driven by that passion. And I acknowledge those of you that are still here to continue this discussion. Also a reminder, there's been a question of materials. Everything is in two places. One is on the AFN website. Also on your lanyards, there's a QR code. Just take your camera, point to that, click on the link, and that will take you to a special site that has all the materials, including resolutions, background information, and everything that has been discussed and provided is online and available. Feel free to share that, also to share with folks back home that they can access all the information on the website. So again, just as part of my closing comments, it's been an honor to be here to witness the heavy discussions, important discussions. But at the end of the day, it is you, the chiefs in assembly, that make the decision. And sometimes there were some comments that sometimes we had to take some punches up here. What I said in my language is "eskam niptaganamugo," and the way sort of the way it's literally translated is sometimes fists are swinging and you accidentally get punched when it wasn't intended for you. So that's the way I'm going to take it. So, but thank you for the comments at the end and the appreciation for sometimes the interesting aspects of navigating the discussions. And I appreciate the support that we have from the Assembly to do the work that we need to do. I'm just waiting on the numbers. And I know that our drum group is standing by as well. So I do see chiefs and delegates entering the room, just to advise everybody that's just joining us, and those online, that we have concluded. We've run out of time, but there's a motion on the floor to extend time to make discussions. Oh, sorry. Can we close the polls, please? I think we were looking at the numbers anyway. So the numbers, the votes for and the opposed, I have. The votes for is 51, abstentions 5, opposed is 95. So the motion to extend time is not carried. But again, just some final comments. I'd like to acknowledge the Assembly. Thank you very much for the honor, the privilege to be here and work with you the last 3 days. And I know that there's further discussion to take place. There's more resolutions that we didn't get to. Those will be discussed in the future. So with that, that concludes my dealing with the resolutions. And I'd like to say thank you to everybody. I'm going to hand it over. Actually, what I'm going to say is meeting adjourned. Session is adjourned, and I will now hand it over to Weena to begin the closing protocols. Miigwech, pinanachum na.
Miigwech Adam. So, c'était un plaisir et un honneur. It was my pleasure and my honor to be here with you all this week, to be co-president for this special assembly for First Nations chiefs. Thank you, everyone here, both online and here in Calgary, for your work, for your hard work to advance First Nation rights and so that our rights are respected. Thank you. I was happy to be able to see all that. For your presence and for being here, all chiefs proxies, for being here to protect and defend the rights of our First Nations. So on that, and it's been an honor to serve you as your co-chair this week. I hope to see you in December. I have thick skin, I think, so. Okay, so great. On that, the meeting is adjourned, so we will now proceed to our closing protocols. And it is my honor to invite to the podium National Chief Cindy Woodhouse Nipinak for closing comments. Miigwech.
Thank you. Well, good afternoon, everyone. I know I've got a little cold, so I didn't want to be around anybody this morning. So, but it's so important that I come and address our chiefs, our leadership. First of all, I want to thank the chiefs for traveling to Treaty 7 territory to participate in our Special Chiefs Assembly over the past 3 days for very difficult discussions about the future of our most precious resources, our children. I also want to thank Tanea and Wakia. Thank you. They led us into the assembly and they will lead us out. This is who we work for. We want to recognize Ontario Regional Chief Abraham Benedict and Anishinaabe Aski Nation Grand Chief Alvin Fiddler for their leadership and their partnership in completing this draft agreement that we reached with Canada in July, and it's a draft. We have been proud to stand with you in support of this agreement, and we will stay by your side as you consider next steps to support First Nations children in your jurisdiction. We also recognize the success of the campaign that defeated this resolution. You spoke with passion and you convince the majority to vote against this $47.8 billion national agreement. And I will be there to work with you, but we must always remember, wherever we land in this new course, that the rights holders must be in control and that the chiefs are in charge. When I spoke to the chiefs at the start of this assembly, we made it clear that my position didn't matter as much as theirs. This is a chiefs' assembly. They have spoken, and I respect the results. Our Assembly of First Nations executive and regional chiefs will be meeting over the coming weeks to discuss next steps. The results of this assembly should be a message to the Government of Canada and all provincial governments in this country that you need to do better. Last year, we had more First Nations children removed from their communities and families than at any other time in Canadian history. Canada and the provinces will need to do more to account for the harms that they have caused by perpetuating a racist child welfare system that has broken so many children in this country. The current system of apprehension and taking kids away is not working. We need to help these families. Since the results, many have asked me, what are we going to do now? I've been getting calls all evening, all morning. Well, we will be thinking about the First Nations children and families in crisis. Our children are watching and continue to wait patiently. We will be thinking of the chiefs returning home and the crisis calls that they're going to keep receiving. We will be thinking of the thousands of First Nations children that have been separated from their families across this country. And we will be thinking of the tribunal plaintiffs that inspired us and spoke so passionately at the Assembly in support of this agreement. Melissa, Noah, Ashley, Carolyn, Richard, you inspire me and all of us to keep fighting. And we can't help but think that the kids and families lost something with yesterday's votes, because the status quo will prevail. I wish we could provide some reassurance that there is no getting around the fact that this agreement was too much of a threat to the status quo. To the industry that has been built around taking First Nations children from their families, it's a big business. Our children. So after I spend the weekend with my family, my children, and elders contemplating these questions, we will get right back to work for First Nations children. We have a compensation program to roll out over the coming months. We have unfinished business regarding Jordan's principle, and we have to hold provinces accountable. Sadly, we have no shortages of issues to work on. We will keep pushing for essential First Nations policing legislation and improvements to Bill C-61 regarding clean water. We will get on with economic reconciliation and unleashing the power of a First Nations economy in this country. While disappointed with the results of the vote, we know our Assembly has come a long way. We have had a difficult discussion, but we are here together, having substantive dialogue about real issues. We are not threatened by different opinions, and we remain united by a common belief that First Nations families should be empowered to look after their own children. So miigwech to Chiefs for your dedication, your passion, and your commitment to the betterment of our First Nations. Thank you to the co-chairs. Difficult job, but you did it with grace and humility. Safe travels home to your families. Miigwech.
Miigwech, National Chief. And just before turning the floor over for the closing prayer, just want to say that Miigwech to all of you, because I say Miigwech to all the chiefs, proxies for being here, for all the delegation, but I don't want to leave without saying Miigwech to all the staff, the translation, sign language, and Core AV, the staff, it takes a big thing to make that happen. And thank you very much for that. And we feel like a family a bit, because a lot of collaboration between all those groups. And thank you to my dear colleague, Adam, co-chair. And thank you. And knowledge keepers and elders, of course. Yes, thank you. Thank you so much. On that, I would like to invite for the closing prayer, Cheyenne Kitsak.
Habojo, Giweden, Noden Disnakas, Makwarodem, Weekwem Kong Donjaba. My name is Nortwin. I come from Wakamakong on ceded territory. It's an honor to be here, to say good prayers for everyone. I'd just like to pray, Creator, that you have pity on us and that you will bless everyone, all the chiefs and all the proxies and everyone that came here today and yesterday over the week. I ask that you will bless everyone, Creator, and that when they go home, that everyone has a safe trip home, and that when the chiefs and council go home, that they lead their people in a good way, and that good blessings come to all of them. Bless all of our children that are out there, the ones that are having a hard time today. I ask that you will bless them so that they have something good to eat today, feed their spirit. Bless their parents, the ones that struggle with addictions, the ones that are outside here in the streets. Bless them, take care of them. Bless their hearts so that they find something good to go pray and learn. Bring their spirit back to them so that they could fight their addictions. I ask that, Creator, today, and that you will bless our national chief and her family. Take care of them wherever they go. All the hard work that she does for our people, protect her and her family and her kids at home. Take care of them. And all the regional chiefs, take care of them and bless all the AFN staff for all their hard work that they do. It's hard work what they do to help. And I ask that, Creator, today, that you have pity on all of us, and that when people leave here today, everyone has good thoughts and good feeling in their heart. With that, I say, miigwech, Creator, naha miigwech, ahu.
And now, Miigwech, for this closing prayer, we will now call upon the drum group for the flag song and the traveling and closing songs. Over to you.